Judgment of the High Court have applied the bar of Article 62(1)(f) of the Constitution upon the petitioner without giving a finding that his declaration of Sanad al-Shahadatul Alamiya in his nomination paper filed in the year 2008 was a dishonest and deceitful action to meet the condition of graduate qualification in order to become eligible for contesting the general election. Apart from lacking such finding, the discussion in the impugned judgment is at best based upon a presumption and not on any finding or deduction made on the basis of any material qualifying as evidence. In the circumstances, the presumption drawn by the impugned judgment is conjunctural and cannot be made the ground for disqualifying the petitioner forever for contesting for holding an office in the constituent legislature of the country, my lord. Now, my lord, there is another judgment, 2019. 2019 SCMR 1939, my lord. Page 1939, my lord. 1943 and 1948 पे my lord इसका 1943 पे my lord relevant citation my lord 1939
नहीं relevant आप बता रहे थे
my lord एक 1943 पे मुलाजा फरमाइएगा पैरा नंबर 7 my lord. Okay. May I read my lord para 7? We notice that the order of returning officer dated 6/4/13 is summary in nature. No evidence was recorded. Para number 7 है my lord.
1943.
Sorry my lord, ये भी उसी पॉइंट को है कि ये RO is not a court. RO is not a court. Para number 7 my lord. We notice that the order of returning officer dated 6/4/13 is summary in nature. No evidence was recorded in the said proceeding, nor does the order give any reason for disqualifying the respondent under Article 62(1)(f) of the Constitution. On the other hand, Learned Election Tribunal made a declaration against the respondent only under Article 63(1)(c) and none under Article 62 of the Constitution. In terms of the said law laid down by this court in judgment reported as so and so, the order dated 6/4/13 by the returning officer merged into the order of the Learned Election Tribunal dated 16/4/13. The disqualification imposed on the respondent by the returning officer under Article 62(1)(f) therefore did not survive. My lord, the relevant इसमें एक minority view क्या था? Minority view भी बहुत relevant है, my lord. That is at page number 1945.
ये पैराग्राफ 10 पढ़ लें. I think ये इशू अब हमारे पास आ गए.
एक कॉपी रह गई मगर मेरे पास.
ये पढ़ें. I am of the view that serious constitutional issues.
I am of the view that serious constitutional issues require to be addressed inter alia, whether the disqualification of the private respondent under clause D and F of sub-article 1 of Article 62 of the Constitution was passed by the court of law or otherwise, whether the disqualification of the private respondent, if any, would be permanent or otherwise in terms of the test laid down in Samuel Bloch case, whether the lack of bona fide on part of the petitioner in invoking the constitutional jurisdiction of High Court under Article 199 of the Constitution and having an alternate remedy under the election laws rendered the petition maintainable or otherwise, whether the disqualification of private respondent could be ignored by this court, keeping in view the law, dicta laid down in Sher Alam Khan and Raja Shaukat Aziz Bhatti case. Accordingly, for the reasons stated herein above, leave of this court be granted to consider and address the issue stated above.
So we are lucky to have this. It wasn't a dissent. It was these questions. The learned single judge, the three-member bench said require consideration.
ये मालूम, ये बिल्कुल ठीक बात.
तो ये तो बात कब से चल रही है कि ये इशू आप फैसला कर लें. ये अब कब की बात है? 2019 की बात.
2019 की बात है.
अगर 2019 अब हम 24 में आ गए 5 साल.
ये अगर आप एक पैराग्राफ और पढ़ लें, ये 2019 SCMR पेज 1943 पैराग्राफ 9 में समी लॉ को फिर डिस्कस किया.
जी मालूम, be that is may, in Samiullah Bloch, we have held that disqualification of election candidate or a holder of elected office under 62(1)(f) of the Constitution comes into existence when he is declared by court of law to lack any of the qualities mentioned in clause F of Article 62(1)(f) of the Constitution. In the present case, the only declaration against the respondent under Article 62(1)(f) of the Constitution was given in summary proceeding by the returning officer on 6/4/2013. As already noted above, no evidence was recorded by the returning officer to sustain his finding, nor he recorded reason for invoking disqualification under Article 62(1)(f) of the Constitution. He is not a court of law but a statutory forum of limited jurisdiction. Therefore, the condition that only a court of law can issue a declaration of disqualification under Article 62(1) of the Constitution.
What I think the point that can be made is that this question that was raised by a bench has been agitating this court for a considerable period of time. Different voices, different judges are saying, like in this judgment also, let's resolve this once and for all. And so it's good that we are resolving it once and for all.
मतलब मैं चंद जजमेंट में लिखवा देता हूँ, प्रिसाइजली बता देता हूँ, बट टाइम क्योंकि बहुत बता दें। मालूम एक है मालूम 2019 SCMR 1684 जी, इसमें ऑनरेबल सुप्रीम कोर्ट ऑफ पाकिस्तान ने ये होल्ड किया कि सुप्रीम कोर्ट आज खुद डिक्लेयर कर सकती है किसी को भी दैट ही इज नॉट ए सगेशियस, ही इज नॉट अमीन।
नेम क्या है ऑफ योर पार्टीज?
ये है निदा खोड़ो वर्सेस मौजम अली खान।
निदा खोड़ो
वर्सेस मौजम अली खान।
Even without recording evidence.
जी 1695 है मालूम इसका रेलेवेंट पेज। 1695 पैरा नंबर 7 मालूम।
ठीक है, नेक्स्ट बताइए।
मालूम इसके बाद है मालूम 2019 SCMR 137 मालूम।
ये सारे मामला 2019 में हुए।
2019 SCMR पेज
है मालूम 137। इसका जो रेलेवेंट पेज है 141 है मालूम।
पेज
141
नहीं, साइटेशन
का 137 है मालूम।
137 रेलेवेंट है पेज 139
पेज 141 मालूम
जी।
इसमें को वारंटो इशू हुई थी और वो ऑर्डर अपहोल्ड हुआ ऑनरेबल सुप्रीम कोर्ट में। ठीक है मालूम। इसके बाद है मालूम
इसमें क्या हुआ था?
वो वारंटो हाई कोर्ट से इशू हुई थी अगेंस्ट ए पर्सन हु वाज अ रिटर्न कैंडिडेट। उसके खिलाफ ये अपील जो थी ऑनरेबल सुप्रीम कोर्ट से, वो ऑर्डर ऑफ डिस्क्वालिफिकेशन पास इनको वारंटो वाज अपहेल्ड मालूम। नो मालूम PLD 2018 सुप्रीम कोर्ट 732 दैट इज फेमस हबीब अकरम केस मालूम। पेज 732। इसमें ऑनरेबल सुप्रीम कोर्ट ऑफ पाकिस्तान की लार्जर बेंच ने ये फरमाया, ये लार्जर बेंच जजमेंट है मालूम।
कितने जजेस?
732 सॉरी मालूम। नो मालूम ये नहीं वो है मालूम
PLD 2018
सुप्रीम कोर्ट
732
ये वो नहीं सॉरी, मैं इसको मैं बताता हूँ। ये सुप्रीम कोर्ट ने इलेक्शन पिटीशन के ऑर्डर पर डिस्क्वालीफाई किया है फिर अपनी जो अपने सुप्रीम कोर्ट ने अपने लेवल पर। ये पेज ना 732 का जो रेलेवेंट पैरा है हमारा वो मैं